on the line. You are not sworn in yet.
All right. Do you swear to translate truthfully to the best of your ability from English to Spanish and Spanish to English?
Yes, I do. Dalia Romero, state certified Spanish interpreter.
Okay. All right.
He can hear the interpreter, Your Honor.
All right. What is your name, sir?
William Corchado Jr.
All right. You have a charge of false imprisonment, battery, domestic violence. Is there a victim present?
And Your Honor, while we wait for the victim to get here, he does qualify for pretrial release.
Okay, what is your name?
Milinés González.
Got to speak up and get closer to the microphone.
Milinés González.
Do you speak English? Just a little bit. So can the interpreter
Yes, Your Honor.
interpret for the witness?
Yes, Your Honor.
Okay. Can you hear each other?
Señora, ¿usted puede escuchar la intérprete?
Sí.
Ok. Necesita contestar en voz alta, por favor. Yes, Your Honor, she can. I asked her to speak up.
All right, so have her tell me her name again.
Nuevamente, díganos su nombre.
Milinés
Milinés. ¿Apellido?
González.
González.
All right. Mr. Corchado has a charge of battery and false imprisonment. We're here today for me to determine what kind of release. You'll be have the option to basically get out of jail with what conditions. So what I need to know from you is whether you're in fear of him.
Señora, el señor Corchado está aquí, ha sido acusado de agresión, violencia doméstica y haberla detenido con pretextos falsos. Estamos aquí para saber qué condiciones de libertad usted quiere que se le impongan a él.
Yo no quiero que esté cerca de mí ni que vaya a la casa.
I don't want him to be near me or come back to the house.
Okay. So I will order him to have no contact with the victim, no return to the residence, not to possess any weapons or firearms or ammunition. Anything else, State?
No, Your Honor.
Is there any history?
There's no violent history, only a narcotics charge out of Puerto Rico from 2001.
All right. On the false imprisonment, there'll be a $1,000 bond, $500 on the battery. And again, the public defender is appointed. All right, that's all, sir. Is that all? Okay. These first three? Okay. All right, what is your name, sir?
Pablo Garcia Hernandez.
Okay, I have a question mark here on probable cause, State. Oh, this is the one where they were arresting her? Is this the one? And he begged them to arrest him instead, and they did? Is that this one? I've never seen that in 20 years, but yeah.
That is the one. Yeah.
she was the aggressor. They were arresting her, and he came out and begged them to take him, so they did.
And it said that he pulled her hair.
That appeared to be after she struck him.
Your Honor, I'm not certain at this juncture whether it was in self-defense or retaliatory. However, from reading the affidavit, the state would assert there's probable cause for perhaps mutual combat, but a battery was committed against her by pulling her hair.
Okay, well, she's here. The problem is, ma'am, you may be charged, so you probably don't want to make a statement because it will be used against you more than likely. But you are, I don't even know that you're a victim from what I see. So I think they just arrested him due to him being intoxicated to get him away from the house. So,
And it appears he also asked for them to take him.
right.
And law enforcement felt that for the safety of the children.
Right, I understand what they did. Yeah, it looks to me, I'm going to find a lack of probable cause and release him ROR. Appears to be on the face of this self-defense as I read it.
And Your Honor, just for record purposes, the state would state that an affirmative defense would not come into play at a probable cause hearing.
Okay, so you're released, sir. ROR. So you may get another court date. Don't miss your court date. The public defender is appointed. Okay?
Okay.
All right. All right, what is your name, sir?
Valentino Rosa.
Valentina Rosa, this is possession of drug paraphernalia, synthetic cannabis. Public defender is appointed, Division 15. Bond at $1,500 and $100. Anything else from anybody?
I'm sorry, Your Honor, how much is the bond for the interpreter? please?
$1,500 and $100. $1,600 total.
And nothing from the state, Your Honor.
Okay, is that the end of the interpreter cases?
I'll be able to get out paying the bond?
Yes, the bond is $1,600.
He also
Okay, thank
has a probation charge.
He has a parole charge? Is he being held on that? Or?
Yeah, the case is D 58745. He is charged on him. It's a charge on him.
Is that set for today?
We don't set court cases.
Right,
for
so
those.
but he's got a hold up for that.
Yeah, it's a no bond. So he
Okay,
won't
so you're being held on the parole violation, so when they resolve that, then you can post your bond on this and be released, assuming they release you on that.
And Your Honor, I believe I'm being told that we have a victim that needs the services of the interpreter.
On this case?
I not on this case, Your Honor. I don't know which case. On felony domestic violence, Cervantes.
Alejandro? Yeah, that's the next case.
Yes,
Okay.
Your Honor.
All right, so we'll keep the interpreter online here.
Yes, Your Honor.
Your Honor, Mr. Cervantes is mental health. He's not coming to court this morning.
Okay, due to his mental health, he's not being brought over this morning. The public defender will be appointed. Did you want to say something, ma'am?
I need translate.
Señora, ¿usted desea decir algo?
¿Me quieren preguntar algo?
Do you to ask me something?
No escucho bien.
She can't hear.
She says that she cannot hear the interpreter. Is that correct, Your Honor?
Yeah, I need yeah.
Señora, ¿usted puede escuchar la intérprete, sí o no?
Sí, ahora sí.
She can hear the interpreter, yes.
All right, well, due to his mental health, he's not being brought over today. Will they schedule that for tomorrow?
Señora, dado al estado de salud mental en este momento, a él no lo han traído aquí en el día de hoy.
So the public defender's office is appointed as his attorney at this point.
La oficina de defensores públicos se le está designando como el abogado para él en este momento
They'll reschedule him for tomorrow if he's able to come over.
y le van a traer nuevamente mañana, si es que le pueden traer aquí a la sala.
Is there anything you want to say in case you're not here tomorrow?
¿Hay alguna cosa que usted quiera decir en caso de que usted no está aquí en el día de mañana?
Yo quiero aclarar que yo el día de ayer no puse cargos en contra de él. Yo en mi declaración lo dije. Yo dije mi declaración en español. No sé cuál fue la traducción que le dieron, porque yo a él no le coloqué ningún tipo de cargo.
I just want to state and make clear that yesterday I did not want to press charges. In the statement that I gave, it was clear that I did not want to press charges. I do not know what they translated.
Okay, well, the state attorney decides if charges are filed or not. So you may want to contact their office.
El fiscal es el que decide si le formulan cargos o no. Así que a lo mejor usted quiera comunicarse con la oficina de la fiscalía.
Okay.
Okay.
Okay, thank you.
Bien, gracias.
And Your Honor, the defense would like to put on the record that Mr. Cervantes does qualify for pretrial release. We would request that a bond be set for him. I understand that he does have mental health, but I believe having a bond set for him so that he could potentially bond out would benefit him and the jail as a whole.
State?
El fiscal ha dicho que el acusado es el elegible para libertad preventiva.
Wasn't the strongest case for the charge either.
It is not, however, it seems as if there's other witnesses as well. However, as far as the firearm's concerned, the witness did not see that occur. The witness saw him with a firearm, but not see him point the firearm.
La fiscal ha dicho que hay otros testigos disponibles que vieron lo ocurrido, aunque uno de los testigos lo vio con un arma de fuego, no lo voy a señalar a nadie con el arma.
Hopefully he'll be brought over.
Esperamos que le traigan a él nuevamente mañana.
Okay, we have another interpreter case or not? Anybody else need the interpreter?
¿Alguien más va a necesitar los servicios de un intérprete?
Okay, we'll call you back if we need you, I guess.
Yes, sir.
Okay,
Thank you.
thanks.
Your Honor, the next case, Scott Keats, is mental health.
Scott keeps his mental health reset. Okay. Public defender's appointed. I have Elbon.
He's mental health, Your Honor.
What was that?
He's mental health.
Mental health as well? Public
Your
defender be appointed? Yes.
On the mental health cases, unless it's felt that he's going to be available tomorrow, would the court entertain appointing the public defender and
What?
appointing the public defender's office and possibly going forward with the IA and a bond?
On Elbon?
On the ones that are showing as mental health resets as opposed to resetting them, with the court entertain
Yes.
doing the IA?
That's what the public defender and you want?
Yes, Your Honor.
So, which case do you want to address?
If we could start with Mr. Keats or Kites?
Scott Kites?
Yes, Your Honor.
Aggravated assault with a firearm, domestic, so there's not a victim here.
No, Your Honor.
So that means no contact with the victim, no return to the scene, no weapons, firearms, ammunition. It's not to consume any alcohol. Bond of $2,500. Anything else from either side?
Nothing from the defense.
Nothing from the state, Your Honor. Thank you.
Okay. Elbon is a domestic battery. I think this is the one he struck the victim with a bag of potato chips or something.
Mr. Albon does qualify
Yeah.
for pretrial release.
So the victim is not here. We will be in order of no contact, no return to the scene. Let's possess any weapons or firearms or ammunition. $500 bond on each charge, battery and the assault. Okay, I have Jose Antuna.
Mental health, Your Honor.
No, okay. PD's appointed, burglary of a structure, trespass, bonds of $3,500 and $150, no return to the scene. Anything else?
Nothing
Nope.
from the defense.
Okay. Wilson is next.
He's medical, Your Honor.
He's what?
Medical.
Okay. Public defender will be appointed. He's out on bond already, it looks like. ROR. He's fishing without a license. Looks like he's done that several times. So the bond will be stayed on the fishing charge of $250. State, what do you want with the, it says sexual battery? He's
Yes, sir.
ROR'd on that? It's kind of strange, but
It might have been a 33-day ROR. I'm not certain.
there's also a battery petty theft with that.
And at this time, the state would ask the court to take no action on the out on bond. And may the state have the city ordinance violation, Your Honor?
Have the case number?
Yes, Your Honor.
2020 MO 794.
Thank you.
What do we know about those cases he's out on bond or out on ROR?
I will
because he's continually violating the law here with fishing. I know it's fishing, but it just shows the willingness to violate the law. If it were the first time, it'd be one thing, but it says he continuously does it.
It appears there was a delay in the case packet arriving at the state's office.
So it was a 33-day motion?
It was a 33-day motion, yes, Your Honor.
And have you filed charges yet, or?
No, the 33-day motion was filed as of July 22nd because we had not received the case packet. Or we had just received the case packet. And looking at the actual charge, it was one that even if we had just received the case packet about a week ago, it would not have been. It's a physically incapacitated victim. And without the case packet.
All right, so you want me to take no action on that and leave the bond at $250 on the new fishing charge?
Your Honor, now that I'm looking at the case, the state is going, because it was a fishing charge, that was why the state was saying that.
Right.
But now that I'm looking at the case and I'm seeing the reason that it has not yet been charged, the state would ask the court at this time to revoke that bond and allow Division 22 to determine what would be appropriate for release.
Okay, so I'm going to go ahead and revoke the bond, or the ROR, set that at no bond at this time. And stay the bond on the fishing charge. And then the public defender's office can file their motions or whatever they need to do. All right. Adnant, Ratika, Zamora. Okay, she's here. The public defender again is appointed. This is an aggravated battery, domestic violence.
Your Honor, she does qualify for pretrial release.
All right, the victim's Kenny Mason. Is not here. Qualifies for pretrial release. All right, so I'm going to order no contact with the victim, separate residence. If the defendant has any personal items there, she can return one time with law enforcement to pick up those items. Not to possess any weapons or firearms. As far as bond state,
Your Honor, I understand that he's pretrial or she's pretrial release eligible. However, the state would point out to the court, while there is no conviction, there is a history of domestic violence arrest with a different victim. And the state would just like the court to take that into consideration when determining bond. The state's recommendation would be $750 for count 1 and $100 for count 2, if the court is inclined.
All right, on the aggravated battery, I'll set bond at $1,000. On the battery domestic violence, it'll be additional $100. All right, next one's Jordan Fair. Division 22, there's an arrest warrant. Battery, domestic strangulation and battery. No victim is present. So we'll order no contact with the victim, separate residence.
In Your Honor, the defendant does qualify for pretrial release.
I'll set bond at $1,500 on the strangulation battery, $500 on the regular battery, Division 22. All right, Nobles is next. Terrell. Division 19, we have new charges of burglary of a dwelling with assault or battery, domestic, battery, domestic, battery, domestic, criminal mischief, trespass in a dwelling. The burglary of a dwelling with an assault or batteries punishable by life, so that'll stay no bond.
Sorry, I'm sorry, Judge. I apologize about that. I was a little bit agitated. I kind of had a sunstroke.
What's that? Okay. All right, so we have somebody present here. Who's present?
Me.
Mother and sister. I'm his sister and she's his mother.
Okay. Because he's charged with the burglary of a dwelling with a battery therein, he's not entitled to a bond today.
I didn't hear you, sir.
He's not entitled to a bond, so he's going to stay in jail until there's a formal bond hearing with a judge to determine whether he will get a bond.
That's fine.
Did you want to say anything else? No?
No, sir.
Okay, so there'll be no bond.
Sorry, sir, Your Honor. We are in fear of him, and we don't want him to come back to the residence because we fear that he is going to attack my mom. I'm actually moving out to a different residence, so my mother's going to be there by herself.
Okay.
And he's been trespassed and told not to come there, but he comes anyway. He brings weapons, he hides them, and he threatens to attack her every time.
I didn't threaten to attack her, Christian.
Okay.
I didn't even put my hands on her.
Hold on.
I'm talking to her as a formal
State
sister.
may want to get their information to make sure you have phone numbers and contact because there'll probably be another hearing in front of another judge to determine those conditions of release, and he'll want to hear from you.
That's fine, but she doesn't pay any bills there.
So make sure there's information. This is the state attorney's office here. She's standing up to your right.
And Your Honor, if I may just get on the record,
Her boyfriend attacked me, Judge.
ma'am, you said you are his sister,
Yes.
and your name is
Kristen O'Day.
Kristen O'Day. And
So tell
ma'am,
Anthony
you
O'Day to
are
keep his hands off.
Deborah Brent Nobles, and you are his mother. And the testimony of both of you is that you fear him.
She fears me because her boyfriend.
Mr. Nobles, just everything you're saying can be heard by the court, so I would recommend you not make any statements at this point.
Okay.
Thank you.
And I'm going to show you the information that I have, and if you could just verify that it's correct. particularly the phone numbers.
Correct.
I know you said you're moving,
Yes.
so if you can just, and your mother would know where you're moving to.
Yes.
So if you could just keep us apprised of where you're moving.
Okay.
All right, thank you.
Okay, so I will state a no bond. I'm going to order you to have no contact with the victims or witnesses.
I'm the victim.
Of course, no return to the scene.
Okay.
You're not to possess any weapons or firearms.
I don't possess any weapons.
And on the 2019 MM 4081 AO, you're out on it's an open case.
Yes, because I think my girlfriend had tried to press charges against me while I was there. Which was, they
So that's an open case.
Yes, she wrecked my hotel room.
M-
And then I called
Mr. Nobles,
So he's
once
not
again,
out in
I'm-
any type of release state, so I won't take any action on that one.
Okay. Thank you.
And the 2 new battery domestic violence charges,
Yeah.
those will have bonds of $2,000 each. Again, no contact, no return,
Thanks, Sheriff.
no weapons or firearms. Criminal mischief and the trespassing will be an additional $100 each.
Thanks, Sheriff. I won't do it again. I apologize about that.
And this is Division 19.
I was just trying to make it to the courthouse.
Okay, so that'll take care of it. He's not going to be released till there's a bond hearing, and if then, he may still not be released. Yes?
Your Honor, do you have documentation in regards to his mental illness? Is there regard that he
I don't have a
is
mental illness, Ma. I have a lazy
described
eye.
as
I don't have-
schizoaffective,
I don't have
bipolar,
You know I have a lazy eye.
schizophrenic?
You know I have a lazy eye and a toothache. Get out of here, Ma.
I can't hear you when he's talking, so.
I'm just telling her. I didn't mean to put my hands on you, but it's still nighttime.
Okay, no, but you're not.
I don't expect to fight in the
All
morning.
right, come on.
Okay, so what do you want to say?
I'm sorry, sir.
That's all right.
Mental illness? I
right,
just
so the-
wanted to make the court aware or make you aware if he has a mental illness.
Okay, the public defender will note that.
I'm sure he knows.
That's more important for him, and of course, the state needs to know that as well. Is there
He has a history of Baker
okay,
acts to Lakeside Aspire, approximately 19 or so that cover a span of about 13 years, and as well as admittance to a long-term treatment center that I provided for him in trying to help him to La Amistad over in the Winter Park area for long-term treatment, and a persistent, there is record of my coming to the court system to speak with the mental health judge for ex partes over our history to get him some sustained support, some sustained help. Of course, the Baker enactment by law is a 72-hour hold, which is typically what they provide, and he is not med compliant, and I have over the years pleaded for assistance with med compliance, to which the response has typically been the state of Florida does not provide monetary support to provide assistance for sustained treatment and that type of thing to track him. But he is in a desperate, dire situation now.
yeah, unfortunately, most people, the treatment they end up with is what they get in the county or state prison system.
Wow.
So,
And the interesting thing is, in pursuit as an educator, I just find it's disheartening because you can see clearly, it's very clear. The handwriting is pretty much on the wall that when they're non-med compliant and will not comply and will not take the medication, or he smokes his medication, it spirals him almost into the abyss. And I simply try to plead with the court, rather than he be a part of the system. That is not my desire, but
yeah,
that's
it's
all I
hard-
wanted
it's
to
hard
say
to make somebody take their medication. I mean, obviously, I can't do that. Public defender can't do that. You can't even make him take his medication.
Yes, sir.
So I don't know what to tell you other than it's a mess, and you know it more than anybody. So
Yes, sir. I just wanted to make sure it's noted. Thank you.
Okay, thank you both. Mhm. Okay, let's see. I have a Richardson next. Yvonne Richardson?
Yes, sir.
Okay, this is battery strangulation, battery domestic, division 50, and I have a PC issue I think I wrote here.
Yes, Your Honor. I have a note that I need to ask for 24 hours. It appears,
We have somebody here that might supply the PC, I don't know.
okay, because it appears that the full report did not upload.
Right. All right. Who do we have? What is your name?
Deasia Griffin.
All right. Will you raise your right hand for us? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. I'm here to decide what terms of release should be placed upon Mr. Richardson here. Are you in fear of him?
No.
No? Do you want him, does he reside with you?
Yes.
Do you want him to reside with you?
Mm-hmm.
You got to speak up.
Yes, sir.
And I'm trying to determine if there's probable cause for a battery. What did he do to you that got him here? If anything, would
We got into an argument.
okay? Did he touch you?
He pulled my hair.
Okay.
Your Honor, may the state where?
Mm-hmm.
Hi, Ms. Griffin. When law enforcement came, did you speak with them? And did you tell them that the manner in which Mr. Richardson touched you caused you to, for a short period of time, have difficulty breathing?
Yes.
The answer was yes?
Was that yes?
Yes.
Okay.
And how was he touching you that made it difficult for you to breathe?
In this area.
So he put his hands around your throat?
Around my neck, like right here. Right here.
Okay.
Yeah, put it out.
All right. And during that time, you said that he pulled your hair. Did you also tell law enforcement that during this time he also struck you with his hands?
Yes, ma'am.
Thank you, ma'am. I have no further questions.
Okay, so you want him to live with you and you're not in fear of him at this time?
No.
Is there any prior domestic or anything state or?
There was a 2018 conviction. It does not look like it was in Florida for aggravated battery.
Do you know anything about that, ma'am?
No.
Ma'am, how long have you been in a relationship with Mr. Richardson?
For 6 years.
6 years? And have all 6 of those years been here, or were some of them in Louisiana?
We've been in Louisiana. We just here visiting.
Okay. And this Louisiana conviction in 2018 was for aggravated battery, and it was out of Louisiana. And you were not the victim in that?
No.
No, it was in
Were you aware of that conviction?
Ma'am.
Ma'am?
Were you aware of that conviction, ma'am?
No.
Okay. And I have no further questions. Your Honor, his history also includes weapons convictions and unknown dispositions that include use of weapons and dangerous instruments, second-degree murder ×2, armed robbery, and bank fraud. There are, however, no failures to appear that are listed, but those crimes of violence are concerning to the state. The state at this time is going to advocate for no contact at this time.
You said you're both visiting here?
We just visiting. I just really want to get him home so we can go home. Get him out so we can go home.
So he does not live here?
No, we don't live here.
Does he have family here?
No, he don't have any family here.
I can speak, Your Honor.
And so, ma'am, you were here on vacation?
Yeah, we here on vacation.
All right. And do you live together in Baton Rouge?
No, not.
Okay. Thank you.
All right, well, from what I've heard, I'm going to order no contact with the victim here. Since you're not from the area, on the battery by strangulation, I'm going to set a $5,000 bond. On the battery, $500. You're not to possess any weapons or firearms or ammunition. It's Division 15, public defender is appointed.
I got a lawyer.
Next one I have is Severson. Thank you, ma'am.
Oh, Your Honor, I got a question. I was wondering, you said no contact. How got to be no contact when we gotta travel back to Louisiana together? She gotta get me out.
No contact. Figure it out. No contact at all.
Yes, sir. Thank you. You have a good day.
All right, Severson.
Yes, sir.
This is aggravated assault, firearm, battery, domestic. Is there a victim here?
No, Your Honor.
Nope. So I'll order no contact with the victim. Separate residence, no weapons or firearms or ammunition. As far as a bond state, do you have any input?
Yes, Your Honor. The state would ask the court to set bond as to count 1 at $2,500, count 2 at $100. And the state would also ask for a no return to the scene order. It appears that the location of the incident was the victim's home.
Okay, no return to the scene. 2,500 and 100 are the bonds. It's Division 11, public defenders appointed. What's your name?
Ty Brown.
You're here on a battery domestic violence. I don't see a victim. So I'll have to order no contact with the victim, separate residence,
Yes, sir.
weapons, firearms, ammunition. I will allow you to return to the scene one time with law enforcement to pick up any personal items. Public defender is appointed. Any history state?
No history, Your Honor.
Bond will be $500.
And Your Honor, Mr. Brown does qualify for a PTR.
I'm going to leave it at 500. Elliot Cunningham? Whoop.
Yes, sir.
There you are. Okay, it's battery, domestic violence. No victim here, so we'll order no contact with a victim, no return to the scene, no weapons, firearms, ammunition. You may return one time to pick up any personal items with law enforcement. Bond of $500. Anything from the state?
No, Your Honor.
Okay. He's appointed. All right. Next one is Israel Alfonso Bonet.
He's medical, Your Honor.
Mentally?
Medical.
Mental issue?
Medical.
Okay, so I'll order, public defender is appointed. Order no contact with the victim, separate residence, no weapons, firearms. And anything from the state?
Your Honor, there appears to have been only a prior battery arrest. There are no convictions of a violent nature. There is some-
$500 bond. So public defender going to waive the arraignment?
Yes, Your Honor.
Okay. Eric Farley?
Yes, sir.
Here on battery, domestic violence, I don't see a victim, so I'll order no contact with the victim, separate residence, no weapons, firearms, or ammunition.
Yes, sir.
State, anything else?
Nothing further as to the conditions of release. The state would recommend a bond of $500, Your Honor.
Okay, we'll set the $500 bond. Public defender's appointed.
I'm sorry, Your Honor, did you say maintain separate residence?
They reside together. Yes, separate residence, no contact with the victim, no weapons, firearms, ammunition. You may
And-
return one time with law enforcement to pick up your personal items.
And for the record, Mr. Farley does qualify for pretrial release.
Okay. Next one's Valencia Pineda,
Yes, sir. Yes, Your Honor.
battery, domestic violence. Nobody's here, so I'll order no contact with the victim. Separate residence, no weapons, firearms, ammunition. Order you not to consume alcohol. Anything from the
Can you-
state?
He does qualify for pretrial release. He has no history.
And without the victim present, Your Honor, the state would object to pretrial release, though the state will put on the record that he has no violent crime convictions, and he only has a public intoxication on his history.
All right, bond will be $500. All right. What is your name?
My name?
Khalil Abdurrahman.
All right, you have failures to appear with no bond, 2 cases.
Yes.
And then you have possession of cannabis less than 20 grams with a $100 bond and drug paraphernalia.
The public
Came in at 500, I'll set that at 100 as well, so each one will be 100. Public defender is appointed.
Your Honor,
Yes?
with regard to 2020 MM 5597,
Can you please repeat it?
the state would recommend ROR as they are possession of cannabis and the paraphernalia is related to the cannabis, less than 20 grams.
Okay, so on the cannabis and the paraphernalia, those will be ROR. All right. Felix Chambers. Public defender is appointed. Okay, state, as far as probable cause on this, and it says they were arguing, he pulled out a knife, but it doesn't really indicate that there was a threat.
Your Honor, it says that Scott was in fear that the suspect was going to cause serious bodily harm.
Right, based on what?
This was based on the interactions with the victim, Your Honor. This was based on the investigation and the conversations with the victim.
Well, for an assault, you need a threat and an act in furtherance.
Yes, Your Honor, and within the four corners of the affidavit, the state would argue that there is the threat. If you look at the statements that are here, the fact that the officer writes that the victim was in fear, and that was immediately following the statement that he pulled out a knife, and then the victim was in fear that he would use the knife, the state would ask the court to find probable cause.
And your victim doesn't want to prosecute, it says?
I'm sorry, Your Honor?
The victim does not want to prosecute, is that what I'm reading?
No, the homeowner didn't want to prosecute. However, the victim stated she is willing to testify and prosecute for this. The victim is Scott.
So they are arguing and he pulls out a knife, so I guess that's sufficient circumstantial evidence for a assault.
And Your Honor, the state would, just for the record, say that the threshold is very low, the standard is very low at initial appearances.
Okay, so technically it's there, it's not very strong, but it's there. What does he have for history?
And he has no violent crime histories, only an arrest for cannabis and an arrest. He does have an arrest for battery, domestic violence.
All right, so I'll order no contact with the victim. No return to the scene. I'll set bond at $1,000. Not to possess any weapons, firearms, ammunition. Public defender is appointed. Next one's Deckel, Kenneth. Deckley, I guess it is.
Deacon, sir, but you good?
Deckel?
Yes, sir.
All right. All right, so it's Division 17, Public Defenders appointed, then there's a Division 12 for grand theft of a motor vehicle. Those bonds are $1,000 each. Anything else, either side?
Sir, they tried to tell me that when my brother tried to bum me out, they tried to say I had 2 holds. So can you check real quick to see if I got any hold or anything?
Does anybody show any other holds?
He has a fingerprint hole and a DNA hole. I guess they never did his APHIS once he came in.
I did get that. I got that done when I came in. I got fingerprinted.
What? He must be stuck in the FDLEQ.
What's that? What's LEQ?
So we'll have the public defender look into it. As far as these cases, you can bond out.
Okay.
All right.
Thank you.
Edwards?
Yes, sir.
Okay, you have trafficking. MDMA, says with a weapon, possession of cannabis with intent to sell or deliver cannabis. Prescription drug without the prescription with intent, and possession of drug paraphernalia. And state, as far as bonds, or count one has a $100,000 bond, everything else is $150 and then $100.
Yes, Your Honor. The state would ask the court to stay the bonds.
Okay, public defender is appointed. Bonds will be stayed. Count one, the bond is $100,000. Okay. Adam Gonzalez? Yes, set it at $100,000. What is your name?
Adam Gonzalez.
All right, you have attempted burglary of a conveyance, bond of $1,000. Division 19, and then a possession of a concealed weapon, brass knuckles. That bond is $500. Public defender is appointed. Okay, next one's Leach.
Yes, sir.
Okay, Division 17, public defenders appointed for the aggravated battery with a weapon. That bond is $3,500. It says you're released on your own recognizance for possession of heroin.
Yes, sir.
And paraphernalia. Was that state a 33-day motion, or what?
Is this Summer Leach?
Leach, yes.
I'm showing that the out on release case is an aggravated battery with a deadly weapon.
Mine says heroin and drug paraphernalia.
That might be a typo on my sheet under 2020 CF 7407. And 7407, my sheet is incorrect, is a possession of heroin.
Okay.
And
It says ROR, which is strange for a felony, but maybe they're doing that now, I don't know. Was it a 33-day motion, or was it a...
it was not a 33-day motion. I believe the ROR was done
And Your
at
Honor,
initial appearances.
it may have to do with the Level 2 drug diversion program that I know the state's running right now. It goes like with what I had spoke yesterday about, typically they do a class and some community service and the case gets no process. That may have been why she was ROR'd.
They do that on the felony possession?
Mm-hmm.
Really?
And again, just looking at the history, I guess I have to go back to the level 2 drug diversion because the history is primarily sale and delivery and manufacture of drugs, so.
Okay, well, I'm going to order on the new battery charge. No contact with the victim. No return to the scene. You're not to possess any weapons, including stun guns. No firearms, no ammunition. Of course, no contact with the victim. That bond is $3,500. So on the ROR case, state, I can revoke the ROR and set a bond, or I can go no bond, or I can leave it.
The state would recommend revocation of the release and a new bond at $2,000.
Okay, it seems reasonable. That bond will be revoked and go to $2,000.
And I guess that would have to be, I think it's 2 counts, it would have to be $500 or $1,000 per count.
Okay, $1,000 per count on the 2020 CF 740780. Rebecca Lewis. Lewis,
Rebecca Lewis is medical, Your Honor.
mental health. All right, public defenders appointed. Aggravated assault with a weapon, burglary, dwelling with assault or battery. So we'll appoint the public defender's office. On the burglary of a dwelling with a battery therein, it's no bond, it'll stay there. On all charges, there's no contact with the victims, no return to the scene, possess no weapons, firearms, or ammunition. Aggravated assault with a weapon will stay at $2,000, the battery will stay at $500. And there's an ROR on a trespass in a structure, the ROR will be revoked. And that trespassing will go up to a $2,000 bond with a no return to the scene on that case. What's that?
Medical or is it mental health?
I don't remember what she said. Was that medical or mental health or
Medical.
mental?
Medical.
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 Medical. Okay, Marty Mitchell.
Yeah.
You have a grand theft, 3rd degree of a motor vehicle. That bond is $1,000. Division 20. And then you have shooting at or within to a building, shooting from a vehicle, criminal mischief, use of a firearm and commission of a felony. It was all per in a warrant signed by Judge Morgan. Those bonds will be stated $10,000, $150, $150, and $150. Not to possess any weapons or firearms. And then you're out on bond. 20 CF 297380. That bond will be revoked and go to no bond. And the 20 CF 719380. That bond's revoked and goes to no bond as well. Angel Pena?
Yes, sir.
Okay. Public defenders appointed on all your charges. Several You have a fleeing and eluding, disregard for safety of persons or property, resisting, fleeing or eluding, aggravated assault, 4 counts, resisting, possession of, looks like drug paraphernalia and possession of cannabis. Reckless driving, attaching tag not assigned. Okay, on the attaching tag, that will be an ROR. Reckless driving will stay at 500. And public defenders appointed on everything. I'm going to order you not to drive a vehicle. Do you have a license, a driver's license?
Yes.
I'm going to order that to be turned over to law enforcement as a condition of your release. You're not to drive. State, as far as bonds. Is there any other history?
On the fleeing and attempting to elude, the state would ask the court to set bond at $3,500. The resisting, fleeing, and attempting to elude, the state would ask the court to set bond at $150. On the aggravated assault, 4 counts, the state would ask that the court set bond at $1,000 per count.
Does he have history?
He has no history, Your Honor.
Okay, on the fleeing and eluding, bond will be set at $3,500. The resisting will be at $500. And then the aggravated assaults will be $1,000 each. And then the other charges of resisting, those will be stayed at $500. Drug paraphernalia and marijuana will be ROR'd each. Okay, 3,500 on count 1, 500 on count 2, 1,000 on 3, 1,000 on 4, 1,000 on 5, 1,000 on 6. Okay? Got everything else? Okay. You got the surrender DL?
Yes. Yes.
And no driving. Okay. All right, what is your name?
Mario Ravello.
All right, you have a failure to appear. There's a bond set of $500. That's in Division 84. And then you have open container of alcohol. Bond set at $250. And then you have possession of meth, MDMA, providing false identification to law enforcement. That'll stay at $1,100. And then you're out on bond on 2020 MN 2751AO. That bond will be revoked and go to no bond. Got it? I'm going too fast, tell me. Got it? Okay, these pointed. All right. Let's take a stretch break here. phone still work. Muscles. All right, what is your name?
Jalissa Suazla.
Okay, you have possession of cocaine and cannabis, bond set at 1,000 and 100. I will ROR on the cannabis. Okay, you're out on bond on a petty theft case, the 20 MM 105880. That bond will be revoked and go to no bond. Public defenders appointed. Lamar Wolford. We have possession of methamphetamines, MDMA, ecstasy. Bond is set at $1,000, Division 10. And then an open container. Bond is set at $250. All right. Anything else on those?
Nothing from the state, Your Honor.
Okay. Willie Wright.
Yes, sir.
All right. Case is Division 11, grand theft motor vehicle resisting without violence. Bonds of 1,000 and 100. PD's appointed. Okay, next one is, last name is PE,
He's mental health runner.
mental health. All right, well, it's a failure to appear. There's a $2,000 bond, public defender's appointed. And that's Division 85, so we can waive his appearance for that.
Yes, ma'am.
Next one is Jason Carabella.
Yes, sir.
All right, this is a traffic charge of driving without a valid license.
He does qualify for pretrial release, Your Honor.
Looks like there's also a DUI. Yes. All right, so I'm going to order you not to drive without a valid license. Appoint the public defender's office. Anything else from the state?
No, Your Honor.
Can you make your, hold on. Your bonds are 500 each. Can you make the bonds?
No, no, sir.
Are these probably no pretrial release?
No, he
Oh, he
does
does?
He does.
All right, we'll put these on pretrial release. Okay. Sure, Ruben?
He bonded, Your Honor.
Bonded, okay. Hart,
Also bonded.
bonded. Errol,
Good morning, Your Honor.
hello. You're here on a petty theft, $100 or more. There's a $250 bond. Public defenders appointed. Anything else from either side? Nope. Okay. Kennedy's next.
Good morning.
Kennedy?
Good morning, sir.
All right, it's a simple trespass. Is this a pleadable state?
Yeah, I was,
And the offer would be an adjudication of guilt, 2 days Orange County Jail, 2 days credit time served, no return to the Palms Mobile Park, and that's on South Orange Blossom Trail, and abide by any trespass warnings and court costs.
Okay. If you want to plead guilty or no contest, the state's offering you an adjudication, which means you'll be convicted of trespassing. Credit for 2 days in jail, so you'd be released on this charge, that you're not to return to the Palms Mobile Home Park, and you'll have court costs of about $273.
okay, Your Honor.
You understand that offer?
Yes.
All right, do you want to accept that?
Yeah.
All right, do you need a lawyer to help you?
No, am I being released?
On this charge, you will be.
Yes.
All right, do you need a lawyer to talk to?
No. I just need the paperwork.
All right, so I couldn't hear you. Do you need a lawyer or want a lawyer?
No, sir.
No? Okay.
I'm pleading guilty.
Are you on probation or any type of other release right now?
Nope.
Okay. Do you have any other questions?
No, I just wanted to know am I being released?
All right. And you understand what trespassing is, right?
Yeah.
They tell you not to come on the property, you don't go on the property.
Yeah, that was the confusing thing. The security guard, he's been speaking to me and everything. I didn't know,
It says 1 month prior you were given the warning, so do not go back there.
Yes.
All right, so to your trespassing charge, what is your plea? Guilty, not guilty, or no contest?
The one we were just talking about, no contest.
I can't hear you. You got to speak up.
Guilty.
Okay, I'll accept your guilty plea. It's a factual basis in the arrest affidavit. I'll follow your agreement. You will be adjudicated guilty. Credit for 2 days in the county jail. Again, no return to the Palms Mobile Home Park, and you'll have court costs to pay, and you'll pay that at least $20 a month starting 60 days from today.
Okay. So I'm being released.
You'll be released as to this charge. Martinson,
Yes, sir.
you're here on a petty theft charge. The bond is $250. Public defender's appointed. Anything else?
That's correct. No, nothing
Okay.
else.
Nothing from the state.
All right. Gregory Morgan, or, yeah, Morgan.
Oh, can I ask him a question?
Yeah, no return on the petty theft case.
How you doing today? Good morning.
All right. You're Gregory Morgan?
Yes, sir.
All right, this is a battery charge. All right, I'm going to order you to have no contact with the victim in this case.
I don't even know who this is, sir. It's a false accusation. I can account for my whereabouts between 11 and 6 o'clock during the day. I was at the Methodist
Okay.
Church.
All right, well, that's really not the issue for today. Right now, there's a determination of probable cause. We'll appoint the public defender. You can discuss that with them. But I'm going to order you to have no contact.
I don't know who that is.
The bond is $500. Anything else, State or Defense?
Sir,
State, Your Honor.
yes, sir. I start work today, and I did not touch this man. I don't even know this man.
All right, well, you're going to have to talk to the public defender's office, sir.
So when do I go to court?
You will get that paperwork. We'll explain to you your court date. Powell is next.
Yes. Stating.
Public defender will be appointed. Petty theft charge, possession of drug paraphernalia, bonds of $250 and $100. And you're out on ROR on 20MM 119280 for a trespassing charge. I'm going to revoke that. The paraphernalia. I'm going to keep it at 100. And the petty theft is 250. And then the trespassing charge, I'm revoking the ROR, and I'm going to set that bond at $2,000.
Well, when will I be going to court on that one, sir? Because I mean, I've been waiting to go to court. I mean, no court date has been established for the R&R, and it's been over what, several weeks. I mean, you say you're going to revert that. I mean, I don't understand that. How long am I going to have to wait for that?
All right, you'll need to talk with the public defender's office.
Talk to a public defender.
And Your Honor, on the petty theft count, could we have a no return? And that would
Yes, there's
be,
no return on the petty theft. There's
that would
two
be
counts,
no return to the Circle K.
So it'll be 1,000 and 1,000.
I ain't worried about that. I'm talking about this R&R, man.
All right, Randall's next. All right, there's an out-of-county violation of probation, and then there is an open container. Public defender will be appointed on the open container. So I guess due to the probation, you don't want to enter a plea on that, I would imagine, right?
Correct, Your Honor.
Okay. So it'll be stayed at 500 on that. Yeah, no bond on that.
Your Honor, on our previous defendant, on Powell, on his out on bond case, the trespass simple charge, it was no action taken. Did you still want to set a bond on that? On the previous defendant?
Are you saying that it was dropped?
Yeah, in the clerk of courts, it stated no action taken on March the 16th.
What does
Your
that mean?
Honor,
The
if
state
I
no
may-
billed it, or what does that mean?
If I may look it up. Your Honor, it was filed on March 16th and has not yet been, if I put in the right case number 2020 MM1192, it is set for trial August 31st.
All right, so that's when we said $1,000 each count, right?
Yeah, so it's just one count.
Yeah, it's just one count.
And
There's
Your
just
Honor,
one?
the state only filed on one count.
All right, so you filed on which count?
Trespass of property other than structure or conveyance.
So the other count will be RORs. I know, but the jail may not do anything unless there's something there. So
Right?
I don't know. I just hear from PDs when that count's not addressed, the person gets stuck in jail and it's a mess. So public defender, how do you want it to read? I'll do whatever you want.
I can look him up in the jail website, see if they have changed it to just one count of trespass.
I can do nothing with it because it wasn't filed on, or I can ROR it. Either way, the jail's going to release him, right? So
I would say to be safe, just ROR him, even on the one that has no action.
okay, so it'll be ROR. course, that may cause a problem now, who knows?
So that would be 1,000 and ROR on that second count that's showing up.
Right, second counts are ROR not filed on. Doesn't mean they won't go back and file it, so.
That was my thought process.
Okay, I have St. Victor.
What he did.
Your Honor, St. Vic is medical.
Okay, these are all out-of-county warrants. The bonds have already been set, so I believe what will happen is Judge Carter will contact the judge there and see if those bonds can be adjusted or not, and then address it in court. So what I understand happens?
Yes, Your Honor.
Okay.
Your Honor.
I have Robert Boyd.
Yes, sir.
Okay. This was reset from yesterday, I believe. Okay, there was a, do you have an attorney?
Sir?
Do you have an attorney?
No, sir. Not for this case, I don't think.
Okay. As I see Michael LaFay in here.
Oh, yes, sir. Yes, sir. I believe he is for this case. I forgot. I forgot that we retained him for this.
Okay, you have several cases. It says you have Ashley Dunbar on a possession of cocaine. That's a public defender?
Yes, sir.
And then on the burglary of a structure, grand theft, that's where Mr. LaFay
Yes, sir.
is listed.
Yes, sir.
Now you have new charges of aggravated stalking after injunction, violation of domestic injunction.
Yes, sir.
So I will appoint the public defender. If you hire another lawyer, then they can take over.
Okay. Sir, may I have a bond for this? It was a misunderstanding. She had
Sir, hold on.
Yes, sir.
The public defender's office, do you want him to speak?
As long as it's not about the facts of the case, I believe you have not set bond yet, correct, Your Honor?
No.
Okay.
Yes, sir. I was living with her, and this is the second time this happened. She came, and
I would recommend not talking about the facts.
okay. I just want him to know because I need a bond. I have a brand new job. I just got my own place. I don't need to be stuck in here. And there's no violence or anything like that. It's just sometimes she's like, call me. It says I can have contact with her only at her discretion. So sometimes she says I can come over, and other times she gets mad and says I can't, and then calls the cops. But I'm not going to have anything to do with her, sir. I'm not going anywhere near her.
Mr. Boyd, those would all go towards your actual defenses for trial, not for what we're here for today, to set bond.
Yeah, I just need a bond, please, sir. Please, there's no violence. There's no...
And we'll take all that into account.
Yeah.
The judge will hear all of that.
Yes, sir. I actually want nothing to I don't want this going on anymore, so you don't have to worry about me going around her. This is miserable. I'm sorry.
Okay, on the new aggravated stalking after injunction, violation of domestic injunction, state, what's your position?
The state would ask the court to set bond on count 1 at $5,000, count 2 at $500, and all of the standard safety conditions. No contact, abide by the injunction, comply with the injunction and possess no weapons, firearms, or ammunition.
Of
Right,
course,
so, I mean,
no
yes.
problem. But may I please have ROR, because I can't afford a bond right now. I just got my own place because of this, and I just started a job. Please.
Sir, that means little or nothing to me. You have an aggravated stalking after an injunction, your bond is $5,000. You're ordered to abide by the injunction. No contact with the petitioner in the injunction. Your violation of domestic injunction has a $500 bond, and then you're out on release. 2019 CF 13691AO, possession of cocaine. That bond's revoked, will go to no bond. And you're out on 2019 CF 15107AO, burglary, grand theft. Those bonds will be revoked and go to no bond as well.
So I have no bond? I'm stuck?
Right, you're not getting out of jail until you see the judge handling those cases.
How come, sir?
Because I said so, sir. Next one is Jerry Daniels.
Mr. Daniels is medical, Your Honor.
Okay. Let's see, this was yesterday. So public defenders appointed. You want me to state these bonds? State at $3,500, $150, and $150.
Are you asking, I'm sorry, Your Honor. Yes, Your Honor, the state would ask the court to state the bonds. No contact with victims or witnesses.
Okay, public defenders appointed, no contact with victims or witnesses, no return to the scene. $3,500, $150, and $150. All right, we have Haddon, Stephen Haddon.
It's behavior, Your Honor.
Okay, public defenders appointed. Trespass on property, you want to waive his appearance, just leave the bond at $500.
Yes,
No
sure.
return.
Yes, Your Honor.
PD's appointed. Jessica Haney.
Mental health, Your Honor.
All right, public defenders appointed. This is an out-of-county warrant. With no bond, they'll be contacting the out-of-county judge and bringing that back to court, I understand. Harrell, A.B. Moses Harrell,
Medical.
medical, okay, the PD's appointed. Petty theft, the bond is $250, no return. To the famous footwear on 5580 International Drive. PD's appointed. Eric Murray,
He's medical, Your Honor.
okay, PD's appointed. The suspended license, habitual. We'll stay the bond. Robinson,
Mental health, Your Honor.
all right, public defender is appointed, and we'll stay the bond, 500. Okay. Averett?
Yes, sir.
Okay, this is violation of drug probation. What is it? Let's see. This is a drug probation from 1998?
Yes, sir. It was regular probation, Your Honor. I was homeless at the time. I didn't live in Florida, and I just didn't report. But yeah, it dates all the way back to 1998, 22 years ago.
That was Judge Whitehead, and guess what? He's still here.
Actually, it was a crack pipe that They tested it for cocaine and it tested positive.
All right, well, I'm going to appoint the public defender's office, and they can get a hold of the appropriate judge. I'm not sure which one that'll be at this point. All right, PD's appointed. Oh, it looks like Division 16. Okay. All right, we have Mark Payton.
It's mental health, Your Honor.
All right. Appoint the public defender. We'll stay the bond at $250. Waive the arraignment or the initial appearance. There will be appointed on all cases unless we indicate otherwise as well. All right, this is a conspiracy charge. And does the state have any input on this one?
Your Honor, I don't have the statute in front of me on what constitutes conspiracy, but I would like to point out for probable cause that there's no allegations that she conspired with Felix Santiago. She never gave any admissions, and he never gave any admissions. The victim never said that he saw Giselle Alvarez. So I think the only basis for this is the police officer believed that she was lying about where she was on that day, and I don't think that that rises to probable cause for conspiracy to commit a first-degree felony.
All right, state.
Your Honor, if I may have just...
Yeah. I think she also has a fleeing and eluding charge, it looks like. Is that?
She does, Your Honor.
All right.
And Your Honor, as the state, when the state read the charging affidavits, it appears that based on the investigation, speaking to the other parties that are alleged to be part of the conspiracy, reading the facts that seem to be a continuation and somewhat the same facts or related to facts of the other two case packets that she has, the resisting without violence and the fleeing and attempting to elude, the state would assert that conspiracy could be found within the four corners of the original affidavit that charges conspiracy, but if you take in total all three affidavits, the state feels that the conspiracy is shown there.
Yeah, I do find there's sufficient facts and circumstantial evidence for the charge, so I will find probable cause. And as far as any history, state?
Your Honor, I don't have access to the history in Osceola County.
Does Osceola have any history?
Yes, Judge, I'm sorry. Ms. Alvarez does not have any priors whatsoever. This is her first arrest, and also she does meet the criteria for a direct pretrial release on all three charges, Judge. 3 cases, rather.
Okay, well, I am going to order her to have no contact with the other participants. I don't know if they're charged as co-defendants or not, state. But
And Your Honor, I'm not certain. I did not see any additional charging affidavits in this morning's. But from reading the affidavits, it appears that at least one other was being charged.
There was a male that got out with a handgun, correct?
Yes, Your Honor.
Yes. And that was Felix Carlos Santiago Rivera, I believe, or is that?
Yes.
Okay. I'm going to order no contact with him. And then I will release her on pretrial release with that condition. On each count? Yes, all three cases. All right, anything else from either side?
Nothing from the state, Your Honor.
Nothing from the defense.
Okay. All right, who do you have next?
Driana
Bonnie, okay. This is a battery domestic violence. I'm assuming there's not a victim anywhere?
They provided a wrong number, Judge, for the victim.
Okay. All right, then I, of course, would order no contact with the victim, separate residence, no weapons, firearms, ammunition. Anything else, State?
No, Your Honor.
And does this one qualify for pretrial or?
This battery is a 907, Judge. It's bond with pretrial release that qualifies. Ms. Bonnie does not have any adult history. She only has juvenile history, and dispositions are undisposed. We don't know the disposition.
Okay, I will set a bond of $500.
Judge, did you want that with pretrial release or no?
No. All right, who do you have next?
Candy Candidate.
Candidate? All right. All right, these are charges of robbery by sudden snatching and aggravated assault. So we'll order no contact with the victim. Anything else, State?
The state would ask for it appears someone else's home, no return to the scene.
All right, no return to the scene.
No weapons or firearms.
No weapons, firearms, ammunition.
And that's all the state is requesting.
All right, and there's a $1,000 bond on the robbery will be stayed, $500 on the assault. Okay, who do we have next?
Amelia Den.
Dan? All right, from what I see here, there's already a warrant served on her revoking the pretrial release in the 20 CF 3531. It's already been served. So that leaves the possession of a controlled substance charge here. Bond is set at 1,000, which I'll stay. Anything else?
Nothing from the state, Your Honor.
Nothing from the defense.
Is that the same one that's already been resolved? Case 20 CF 3531 has already been served, revoking the pretrial release. Is that what she's?
Judge, I believe that case number is 20 CF 351.
Yes,
That was served.
that's already taken care of.
Yes, Judge, she's in custody on it.
Okay, so I don't need to address that.
No, sir.
I'm just a controlled substance. Okay. All right, who else do we have?
Melissa Hoppy.
Abdi? Okay, this is a petty theft. Says third or subsequent offense. Bond was set at $1,000. I'm going to order her not to return to Walmart. Anything else? Okay.
Judge, I'm sorry, Judge. Ms. Hobby, she's already out on bond in Orange County, case number 20CF 7425 for child abuse and also a DUI with personal property in case number 20CT3848 at 1,000. She was released on July 1st of this year. She also has a notice to appear for petty theft, Orange County, case number 20MM305A, that was sent out on June 20th. Did you want to take any action on those?
Yes, the one she's out on bond, those cases, those bonds will be revoked and go to no bond. And we'll take no action on the notice to appear.
Thank you, Judge.
Mhm. Okay, who do you have next?
Martha Obregon.
Okay, this is a battery charge. There's no victim here, so I'll order no contact with the victim, separate residence.
Judge, I actually spoke to the victim, and he's going to be leaving the residence, so Ms. Obregon can return home. They have children in common, so he will be leaving the residence prior to her returning home this evening. So he wants her to go back, but he does not. He's requesting no contact.
All right, so there'll be no contact. She may return to the residence after he has left.
Also,
No.
she has no prior history, Judge. This is her first arrest.
Okay. We'll order her not to possess any weapons or firearms, any ammunition, no contact with the victim.
And
So-
Your Honor, may I have this inmate's name, please?
The first name is Martha,
Martha Obregon, I'm sorry.
and then the last name is hyphenated. It's,
Yes.
I found it.
you found it?
Yes, Your Honor, thank you.
Okay. All right, so I'll set a $500 bond. Is she able to make that?
I'm not working right now.
Can she make the $500 bond?
One moment. I she should be able to bond out.
Okay. Anything else on that case?
Nothing from the defense.
Okay.
And nothing from the state, Your Honor.
Who else do we have?
Shauna Tooney. This was a reset from yesterday.
Right, the state has provided me with a sufficient probable cause affidavit.
Oh, I did not. I didn't receive that.
And provided it to your colleague here in Orange County.
I have received the probable cause affidavit.
All right, do you have any challenges to probable cause?
No, Your Honor.
Okay. So there's a probable cause. And let's see, so we have, this is a DUI,
Yes, Your Honor.
and there was some things from out of county yesterday, from what I vaguely remember.
There was a Brevard County case under 2019 CF 13034 that she's out on bond on.
All right. Well, I don't have any authority
No, Your Honor.
to do anything with that. You can contact that office over there if you choose to and see if they'll do a motion to revoke bond if that's what you want. State. So I will, what did the bond come in at? Nothing? Bonds,
It came in as
500.
500.
Okay. So the bond stayed at $500. And that should take care of her. Is that all the females?
We are done with all the females. It'll take a minute or so, and they're gonna take them out and bring the males in.
Okay.
So,
Just let us know when you're ready. Yeah, let us know when you're ready.
okay.
I think our domestic violence caseload's going to be going up.
Oh, yeah. Absolutely.
That's all we see.
As long as Miss Rimmer stays, I'll be all right with it. She leaves, I'm in trouble.
Yes, you will be.
They tend to be the most involved clients as well. All my colleagues have a hard time getting a hold of their clients. Mine call me 3 times a day.
Remember that if you consider going into family law.
Oh, I always, from the time I started law school, I said the one thing I don't want to do is family law, and then they put me in this division, and I was like, all right, cool, doing family law, that works.
And state on the Brian Rivera case, I don't know if you have PC affidavits, it's like the one from yesterday, there's really,
Your Honor, the state intends on requesting
Okay.
24 hours. And I remember now why this is happening. The Osceola agency is the one that does the actual investigation of the DUI, just fills out this paperwork. The officer that does the stop submits supplemental reports,
that doesn't
but
make it.
they don't make it here for IAs. With St. Cloud this morning.
We're ready, Your Honor.
Okay.
I don't think I'm gonna have the same one for Kissimmee though. I don't know, Kissimmee records.
Almina,
They'll be there.
Ronald. Okay. A charge of aggravated assault with a weapon, that bond was set at $1,500.
The jail, I don't know if you can do this. The jail is asking to reset Mr. Almina for tomorrow because they want.
Judge, I actually spoke with Ms. Mendoza. She's our mental health counselor here at the jail. She advised that she needed to speak to Mr. Almina in order to evaluate him for mental health. So other than that, Mr. Almina, he's currently out on bail in Osceola County case 20CF1746, burglary on occupied conveyance, also possession of burglary tools, 500, and he was released on June 18th. He's also out on a conditional release in Orange County, case number 18CF3538, burglary of a conveyance and criminal mischief. He has a competency hearing set in January of next year. So this is all that stems with it.
All right, well, the public defender will be appointed on these cases. I'm going to revoke those bonds. 2020 CF 1746, go to no bond. And the same with the, well, I'm not going to, since he's already got a competency hearing on the 3538, I'm not going to take any action on that one. And the bond on this will stay at $1,500 with no return to the scene, no contact with the victim. And then the public defender's office can obviously file motions and do what they need to do with the competency issue in all these cases. Okay, anything else?
Nothing.
Okay, all right. Brown is next. Savon Brown. He has a failure to appear, no bond. And that's all I have for him. Next one is Carilla Rivera. Brian?
This is
I
a
just
Spanish
spoke-
interpreter matter.
Right, I just spoke to the state on this. I told them there wasn't probable cause, so they're asking for a 24-hour reset.
Yes, Your Honor.
The
So we'll just reset him and get the interpreter tomorrow. Otherwise, his bond is stayed. So if he can bond out, he can still get out.
I don't have any way to communicate that to him. But,
Okay, well, there should be somebody telling him what his bond is.
Yeah.
Okay, Sanchez? All right, this is a battery charge. The victim is not around. Did anybody speak with the victim?
No, Judge, we were unable to contact the victim.
Okay, so I will order no contact with the victim in this case, no return to the scene, separate residence, no weapons or firearms or ammunition. And as far as any history,
Judge, Mr. Sanchez has history stemming from 2008 to 2016. Most recently in 2016, possession of cannabis, paraphernalia, and a duelis. He was sentenced to probation and adjudicated guilty on that. Grand theft, burglary of an unoccupied dwelling. His last conviction was 2016, Judge.
all right, so I'll set the bond at $1,000. Anything else on that one? Okay. Santiago Rivera's next.
Unable to come to court due to medical reasons.
Medical reset. All right, well, the public defender is appointed already, so we'll reset that in Osceola, I imagine, next week. All right, anything, who else do we have there?
Wallace Kahn.
Who is it?
Wallace Kahn. It's an out-of-county warrant.
Did I mix that up somewhere? Okay, Mr. Collins here. This is an out-of-county warrant, bond of $5,000. Anything else on this one?
Nothing from defense.
And
Okay.
nothing from state.
I believe that's everyone.
All right, you have a good day over there. Okay, end call.